Already. I'll just introduce and then we can start the session.
Yeah, sure.
Good evening, everyone. Welcome to this sixth session of webinar skills on practical litigation by Nyaya Forum. Today, we are pleased to inform you that we have Mr. Sourav Roy, advocate on record at the Supreme Court of India. He is a Nalsar alumnus and he graduated from Nalsar in 2013. He did his master's from University of Cambridge in 2015, where he was a Commonwealth Shared Scholar, and currently he runs his own litigation practice at the Supreme Court, where he is primarily focused on commercial litigation and arbitration in the energy and the infrastructure sector. Today's session will be he'll be covering the following topics: pleadings as to how to draft civil appeals and special leave petitions, how the Supreme Court works, jurisdiction of the Supreme Court, the Chief Justice's position among all other judges, the role of an AOR and the AOR examination, and the relevance and importance of Article 32, 136, 141, and 142 of the Indian Constitution. Without any further delay, I ask her to start the session.
Thank you so much for that introduction, and good evening, everyone. I am grateful that the Nyaya Forum decided to invite me for a talk, and the topic that we decided for this evening that I thought would be relevant for all of you is, as Ankush described this, practice and procedure of the Supreme Court of India. Now, practice and procedure before the Supreme Court or any other court could mean a lot of things. It is difficult to come up with an exhaustive list of items which you can say forms a part of practice and procedure, because one ought to know everything under the sun, right? You can't really say that this aspect of practice and procedure is fundamental, whereas some other aspect of practice and procedure is not fundamental. And therefore, while it is very difficult to come up with an exhaustive list of things that one ought to know in order to familiarize oneself with the practice and procedure, I have decided to speak on 5 essential elements of practice and procedure before the Supreme Court of India. Like I said, this is a non-exhaustive list, and the reason why I came up with these 5 topics is I thought that if one is to familiarize and be conversant and have an overview of practice and procedure before the Supreme Court, knowledge about at least these 5 items, these 5 topics is important. So today I'm broadly going to cover 5 topics. There will be subtopics under that. And if you have any questions, we can take them at the very end. What we will look at as part of today's talk is the following. First, we will look at the Supreme Court's jurisdiction. It is a fundamental element of practice and procedure before the Supreme Court. You should be familiar with the kinds of matters that the Supreme Court deals with. And this we will look at under the heading jurisdiction. The reason why this topic is important is because the Supreme Court exercises jurisdiction over a wide array of matters. It can hear writ petitions under Article 32, where you directly approach the Supreme Court. It can hear appeals, where the High Court has certified that it is a fit case of appeal before the Supreme Court. It can also hear appeals by means of special leave, where the High Court has not certified, but you go up to the Supreme Court directly and pray that you be granted special leave for your matter to be heard. Besides, it hears civil appeals, statutory appeals from appellate tribunals, and it also has jurisdiction in some unique matters. For instance, rendering an advisory opinion to the President of India under Article 143 of the Constitution. So therefore, when you talk of jurisdiction, it is not just its jurisdiction as an appellate court that you are concerned with. And therefore, if you want to understand practice and procedure before the Supreme Court, you ought to know the different kinds of matters that the Supreme Court hears. And you also ought to know what the jurisdictional threshold for each of those matters is. So for instance, the threshold that you have to meet in order for your appeal to be heard from a decision of a high court may not be the same as the threshold that you have to meet if your writ petition, where you have directly approached the Supreme Court, is to be heard, right? So under this heading, which is the first thing that we will cover, we will look at the jurisdiction that the Supreme Court enjoys and the diverse range of matters which the Supreme Court hears. And we will look at the jurisdictional threshold for each of those matters that you need to satisfy in order for the court to hear you. After jurisdiction, the second thing that we will look at is pleadings. Now that's again a very important element of practice and procedure. The rules, regulations, conventions, and practice will have come up with some norms on what your pleadings should contain. What you draft by means of a petition is what goes before the judges and will in most cases be the first impression of the matter in the mind of a judge. More importantly, when you are arguing, you can't really set up a case which is beyond what you have pleaded. So in this second topic, when we look at pleadings, we will look at how to draft different kinds of matters that the Supreme Court hears. How do you draft and plead a special leave petition, civil, versus how do you draft and plead, say, a special leave petition, criminal? How do you draft and what do you plead in a statutory appeal? Say, suppose you are going up in appeal from the National Company Law Appellate Tribunal to the Supreme Court. How do you draft that appeal? After pleadings, the third thing that we look at is basically the way the court functions, the nitty-gritties. Now, this is very important because under this, we will look at the matters that the court hears and the bench composition. When you practice before the Supreme Court, you have to have an idea about what bench, you can't bench hunt, of course, but you have to have an idea about how matters are allocated to benches. For instance, you hear of a division bench, you hear of a 3-judge bench, you hear of matters that are placed before a 5-judge bench or a 7-judge bench or a 9-judge bench, 13-judge bench. How does a matter travel in the Supreme Court? Which matters go to a division bench? Which matters can be heard by a registrar? Under what circumstances can a matter be heard by a 5-judge bench? So in this segment, which will be the third topic that we will cover, we will look at how the court functions, the nitty-gritties, allocation of matters, strength of bench, matters that can be heard by the registrar, so on and so forth. The fourth topic of today's discussion will be about the system of having advocates on record. As you know that the Supreme Court has a process where by virtue of an examination, an advocate can qualify as an advocate on record after a certain number of years in practice. Initially, when I was contacted, I was asked exclusively to speak on the subject. I'll touch upon it. Briefly, I'll give you an idea of what the AOR practice is all about, how the examination is conducted, and the rights of audience that an AOR enjoys, and what is it about an advocate on record that makes them such an essential feature of Supreme Court practice. And the fifth thing that I'll discuss today is the relevance of some of the more important constitutional provisions that are unique to the Supreme Court, just to give you an idea and flavor of the position of primordial importance it has under the Indian Constitution. So I'll begin right away with the first topic or first heading of today's discussion, and that is jurisdiction of the Supreme Court. Now, before I deal with the different kinds of matters that the Supreme Court hears and the wide array of jurisdiction it has, I wanted to highlight one very important thing about jurisdiction per se. And this is not just about the jurisdiction of the Supreme Court, but jurisdiction of any court. And this is something which, when you start practicing, you will realize as soon as you start dealing with matters on your own. One has to be extremely thorough and certain about jurisdictional questions. What do I mean by that? In very generic and basic terms, jurisdiction means a court's power or authority to hear a matter. It could also mean a tribunal or an arbitral tribunal's power and authority to hear a matter. Now, what confronts you when you start practicing is the requirement of a lawyer being very certain about which court will have the jurisdiction to hear your matter. That's very important. I'll give you an example. Somebody comes to you in a criminal matter, not an appeal before the Supreme Court, not even pending before any court, but simply comes to you with a plea that he or she wanted to register an FIR, and the FIR couldn't be registered because the police didn't register. You have to know where and who has the right, power, and authority to hear this grievance of your client. What do? Do you go before a magistrate and file a private complaint? Do you go before a high court in a writ and seek a mandamus so that the authorities be directed to register the FIR? Do you go before some other court? So therefore, in criminal practice, for instance, you must understand the basics of jurisdiction. What can a magistrate do? The powers of a sessions court, which court has jurisdiction to grant bail? If there's a specific offense like money laundering, what are the powers of an adjudicating authority or a special tribunal? Similarly, you could take many other examples. You could take civil, commercial, factual situations where the jurisdictional aspect you will have to confront very early on. You've purchased, for instance, a very expensive commodity from a supplier. Which commodity is deficient in terms of quality? Which court will have jurisdiction to hear your grievance? Will you go under the Consumer Protection Act to the Consumer Forum? Should you satisfy, should the jurisdictional threshold be satisfied and you are a consumer? Will you file a civil suit for damages? Can you file a commercial suit under the Commercial Courts Act? What I'm trying to highlight and stress here is that it is not enough for you to know what remedy or relief to seek. It is equally important for you to know which court has the power, authority, and jurisdiction to grant that relief and remedy, right? So always in practice and procedure, be familiar and be thorough with the different kinds of jurisdiction, the various courts, appellate courts, tribunals, arbitral tribunals enjoy. And this is a lesson that's applicable across the board, irrespective of whether you are in criminal practice, civil practice, cross-border disputes, whatever be the case, right? So having stressed upon the importance of jurisdiction, I just wanted to straight away deal with the different kinds of jurisdiction that the Supreme Court enjoys. And today we are going to look at the kinds of matters and the range of matters that the Supreme Court has jurisdiction to decide, and we'll take them up one after another. So for today's talk, we will first look at the Supreme Court's jurisdiction under Article 32 of the Constitution of India. We will look at, like I said, its jurisdiction as an appellate court. We will look at its review jurisdiction. We will then look at its jurisdiction as a court which has powers to transfer matters from one court to another, again, a unique power. We will look at its jurisdiction to try suits under Article 131 of the Constitution. This is again a very unique power where the Supreme Court ordinarily, which only hears appeals and writs, also has the power to decide suits in exercise of original jurisdiction. We will look at its jurisdiction as a court which can entertain curative petitions, PILs, and briefly look at its jurisdiction in relation to advisory opinions rendered to the President, and also in relation to matters concerning election of President and Vice President. With that, I move on to the first subheading under jurisdiction that we'll consider today, and that is its jurisdiction as a court which you can move as a court of first instance under Article 32 of the Indian Constitution. What I would suggest is that maybe you can have a copy of the Constitution handy or just open it on another screen when I refer to an article. It'll just be easy for your ready reference. And because we are now on Article 32, it would be worthwhile to have a look at what Article 32 says, because that will give you an idea about the Supreme Court's jurisdiction to entertain matters under this article, right? Article 32 is about the Supreme Court's powers to grant remedies for enforcement of fundamental rights, right? Now, the first thing that you must remember about Article 32 is the fact that this is not a jurisdiction that the Supreme Court enjoys as an appellate court. It is not a court of appeal when it is dealing with an Article 32 matter. A litigant can directly approach the Supreme Court in an Article 32 petition for enforcement of fundamental rights, right? So that's the first threshold. It need not be an appeal, you can directly approach. The second thing that you have to consider is what remedies can the Supreme Court grant in an Article 32 petition. And if you just look at Article 32(2) of the Constitution, it says that the court shall have the power to issue directions, orders, writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Now, there's one thing that I want to stress on over here. It is the phrase, in the nature of the following writs. Therefore, the Supreme Court's power under Article 32 is not just restricted to issuing the 5 writs. It can issue any order or writ that is in the nature of the 5 writs. So you need not always be able to make out a cause of action for the 5 writs. But as long as you've prayed for an order in the nature of one of the 5 writs, provided of course you satisfy the respective criteria of what you've prayed, the Supreme Court can entertain a petition. Now, Article 32 is a part of basic structure. It's in fact a part of Part 3 of the Constitution itself. You can look at the decision in Quixote Holohan, which says that this particular article, the remedy that one has to seek enforcement of fundamental rights, is itself a part of basic structure. Now, I am told that yesterday you had a talk on the High Court's jurisdiction under Article 226 and 227. And this is again a practical aspect of practice and procedure that I wanted to discuss. You are a lawyer who's been approached by a client who wants to file a writ petition, say a petition praying for mandamus. The question that you have to answer is, which court should you approach? Should you approach the Supreme Court directly under Article 32? Should you approach the High Court under Article 226 and pray for a writ there? What should you do? And this is always a dilemma that one has when there is a fit case for filing of a writ petition. Of course, if it is not extremely important, if it is not an egregious violation of a fundamental right, then the natural intuition is that one moves the High Court instead of the Supreme Court. But this dilemma is better resolved if you actually compare the powers of the Supreme Court under 32 with the powers of the High Court under 226. Why do I say that? It is because though the High Court has the power to issue a writ under 226, and the Supreme Court also has the power to issue a writ under Article 32, there are some clear-cut situations where it is only the High Court that can issue a writ and not the Supreme Court. Now, what are those situations? For that, just have a look at Article 226 of the Constitution once, which says that the High Court's power to issue certain writs. 226(1) says, notwithstanding anything in Article 32, every High Court shall have the power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases any government within those territories. So this is very important. Article 32 is for enforcement of fundamental rights, which are a part of Part 3. Fundamental rights under Part 3 are enforceable against the state, for which you need to look at Articles 12 and 13. 226 does not restrict its ambit to just fundamental rights. It also does not restrict its ambit to the state or government alone, because the language that is used is the High Court can issue a writ to any person or authority, including in appropriate cases any government. Therefore, it is not just restricted to the state. It is not just restricted to the government. It can in fact be issued to any person, including to a government. That therefore is the first point of distinction in between a 32 and a 226. 226, the threshold, the respondent, need not always be a respondent against whom you have fundamental rights. It can also be any party which discharges public duties, but falls short of being a government, a state, or a state authority, right? Now, continuing with 226(1), the High Court, you will note, also has the same powers to issue directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari, or any of them, for purpose of enforcement of any rights under Part 3 or for any other purpose. This is the second point of distinction. Article 32, writ to the Supreme Court, can only be where your fundamental rights are violated. Whereas under 226, you can move the High Court, not just if there's a violation of fundamental right, but for any other purpose, which includes violation of legal rights by an authority which is otherwise discharging a public duty. Therefore, always remember that if it is not protection and enforcement of fundamental rights that you are filing a petition for, then the Constitution itself, I'm not talking about an exercise of discretion where the Supreme Court throws you out because it feels it's not a matter serious enough under 32. But where you're not seeking a protection of fundamental rights but legal rights alone, the Constitution itself bars you from filing a petition under 32. You must only move the High Court under 220. In summary, therefore, if there's a serious violation of fundamental rights and you're agitating that against the state, by all means, consider if you want to move the Supreme Court under 32. If you're looking at enforcement of legal rights against a body which is discharging a public duty, which may not strictly be government, then you must move the High Court under 226 and not 32. Besides that, there are two other elements of practice that are important to remember when one talks of 32 and 226, and that is under 32, the Supreme Court always has a discretion to not entertain a petition if it's not serious enough. And if it is malified, then of course the Supreme Court can impose exemplary costs, including if a PIL is filed under Article 32, that it finds completely frivolous or malified or a waste of court's time. Therefore, the discretion is always there. Just because you are able to show that there's an infraction of a fundamental right is not enough. The Supreme Court may still exercise its discretion, dismiss the petition. It can exercise its discretion and say that fair enough, it seems there's an infraction of a fundamental right, but not serious enough for you to come to the Supreme Court directly, and therefore it may remit the matter back, not remit the matter back, but send the matter rather to the High Court, which can consider appropriate prayers for violation of fundamental rights, even under 226, right? I thought of a few relevant cases under 32 that you would consider worthwhile, and these are examples for you to just keep in mind. Recently, for instance, Arnab Goswami, in his petition assailing the various FIRs that were filed against him, moved the Supreme Court directly under Article 32, alleging a breach of fundamental rights. The court treated the matter with seriousness and did not send it back to any high court, but some relief in the interregnum was granted. That's an example of a matter where the court was satisfied that a serious violation of fundamental rights has been met and therefore entertained the petition under 32 issued notice. There are other cases under Article 32 that the court considers by means of PILs, of course, where the locus standi is relaxed, and some of the most important changes to the governance and polity of this country have happened by means of Supreme Court's PIL jurisdiction under Article 32. Various questions of judicial reform, like for instance, when the 4 judges had conducted a press conference against the way matters were being allocated by the then Chief Justice Deepak Mishra. Some PILs under Article 32 were filed. You could look at Ashok Pandey's case or Shanti Bhushan's case, which dealt with Article 32 PIL matters where the Supreme Court decided important questions of the Chief Justice being the master of the roster and how matters will be allocated, so on and so forth. In the past, in Article 32 matters, several other important questions by means of PIL has been decided, which include matters of environmental law, protection of under trials, entrenchment of fundamental rights, appointment of people to high offices. The CVC's appointment case comes to mind. At the same time, some important questions of government formation and relationship in between governor and speaker, questions of legislative privilege, powers of the speaker and governor have also been decided in matters that were taken up by Article 32 petitions, which were not matters which went up by means of appeal to the Supreme Court. I'll give you a few recent examples. For instance, the recent petition that was filed regarding the Speaker's decision to disqualify or not disqualify MLAs in the Karnataka Assembly case after the elections that were held was taken up by means of an Article 32 petition. Recently, in case of the Madhya Pradesh Assembly, in relation to disqualification of certain members, privileges of the Assembly and the Speaker's discretion to call for a floor test and the relationship between governor and speaker was also taken up by means of an Article 32 petition. Therefore, always remember that the court will consider in its Article 32 jurisdiction cases that involve a grotesque violation of fundamental rights. And if that the court is satisfied on, if it feels that indeed that calls for the Supreme Court's decision, then a petition will be entertained. But unless short of something which is of enormous constitutional significance and enormous significance in terms of a breach of fundamental rights, it is very likely that the petition will either be dismissed or dismissed with costs, or the matter will be sent to the High Court to be decided under Article 226. Right, I will now move on to the Supreme Court's jurisdiction as an appellate court. So far, we were looking at Supreme Court's jurisdiction where you can approach it directly. And if you look at the Supreme Court's jurisdiction as an appellate court, broadly speaking, the most common article that you will have to deal with is Article 136 of the Constitution of India, under which the Supreme Court grants special leave to appeal. But beyond Article 136, you also have to familiarize yourself with the Supreme Court's appellate power, where the High Court has certified that it is a matter that is fit for the Supreme Court to decide. And that happens under Articles 132, 133, and 134 of the Constitution of India. We will deal with this, therefore, in two separate categories. We'll look at 132, 133, 134 first, and then separately, we will look at the Supreme Court's jurisdiction under Article 136. Right? So for a moment, just take up Article 132 of the Constitution of India. Article 132 talks about the appellate jurisdiction of the Supreme Court and appeals from the High Court in certain cases. The first thing that should strike you is not all cases, but certain cases. Now, which are those certain cases? That's set out in the article itself. One can appeal from a judgment, decree, final order in a civil or criminal proceeding if the High Court certifies that there's a substantial question of law as to the interpretation of the Constitution. Those are the elements, therefore, that you need to satisfy for the Supreme Court to exercise its jurisdiction under 132. It has to be from a decision of the High Court, which was a judgment, a decree, or a final order. Therefore, it can't be from an interlocutory order. A High Court grants an interlocutory injunction, says status quo in a property dispute till the matter is decided. You can't directly go up to the Supreme Court under 132. That's the first thing. There has to be some finality in the proceedings. It can only be from a judgment, decree, or final order. It can be either in a civil or a criminal proceeding. But the High Court has to certify. Now, this is very important. Without that certificate, you can't go up in an appeal under 132. And when will High Court grant that certificate? Where there is a substantial question of law as to the interpretation of the Constitution. Therefore, it is not merely that the High Court will grant you the certificate where there is a question of general importance or a question of public importance, or where it is expedient that the Supreme Court answers the question, or where there is a conflict between two High Court judges. It will only grant that certificate where there is a substantial question of law involved that entails an interpretation of the Constitution, not general laws, not a statute, right? So these are the 4 or 5 things that you need to satisfy if you want to invoke the Supreme Court's jurisdiction under 132. Honestly speaking, most matters nowadays are taken up by means of 136. So people don't take the trouble of going to the High Court to obtain a certificate of appeal, certificate of fitness. If you contrast 132 with 133, the only difference is 133, Article 133, speaks of an appeal from a civil matter. 132 talks of civil and criminal matters. 133 is only civil matters. You need a certificate of the High Court either way. But in Article 133, in a civil matter, the High Court has to certify that there is a substantial question of law of general importance. This is the difference. In 132, the High Court was looking at whether there is a question as to the interpretation of the Constitution. And if there was, it could have referred a civil and criminal matter. In 133, the High Court need not consider that there is a question as to interpretation of the Constitution. But as long as there is a question of general importance in a civil matter, the High Court can certify that it is a fit case for the Supreme Court to hear. So this is the distinction. It need not be about interpretation of the Constitution, but it can be any question of general importance in a civil matter. Now 134, and this is basically the three articles which I want to cover as one category: 132, 133, 140, 134. 134 is interesting. It is, the head note says, appellate jurisdiction of the Supreme Court in relation to criminal matters. Now you've considered 133 and 132, where there was a question of fitness and a certificate being granted by the High Court in any matter where there is interpretation of Constitution involved or where there's a question of general importance. 134 speaks about two kinds of matters where the Supreme Court will absolutely have appellate jurisdiction. And that is in terms of Article 133(1)(a) and 133(1)(b). And that is where a person's acquittal has been reversed by the High Court and the person's been sentenced to death, or a case where the High Court has withdrawn a case from a subordinate court and sentenced the person to death. Remember, in those two categories, you are not talking of a High Court certificate. You are not talking of a question of law of general public importance. You are not talking of a question of law involving interpretation of the Constitution. But as long as an acquittal has been reversed and a person has been sentenced to death, and as long as the High Court has withdrawn a matter to itself and sentenced a person to death, Article 134 is satisfied in terms of 134(1)(a) and 1)(b). 134(1)(c) of course says that the High Court has satisfied that it is a case that is fit one to appeal before the Supreme Court, right? Which is basically similar to what we looked at in terms of the High Court certificate under 132 and 133. Only difference is 134, the language is unqualified. It doesn't say that it has to be a matter where the High Court feels there's a substantial question of law as to interpretation or substantial question of law of public importance. It says High Court must just certify that it is a fit case for appeal to the Supreme Court. But always remember 134(1)(a) and (b), where a death sentence is concerned, which requires the Supreme Court to compulsorily have to look at the matter. Right? Now that we've looked at 132, 133, 134, I wanted to stop here for a moment and say that these are all matters which, broadly speaking, concerns a High Court certificate. High Court grants a certificate one way or another, saying that this is a question which meets the criteria threshold laid down by the Constitution. The Supreme Court should hear it. 136 is a completely different regime altogether. Under Article 136, the Supreme Court can grant special leave to appeal. Consider this article for a moment. It doesn't talk of a certificate by the High Court. It doesn't talk of a right to file an appeal. It is not as if you will have in all cases a right to approach the Supreme Court in an Article 136 petition. But it talks of the Supreme Court's power to grant special leave to appeal to the Supreme Court. Now read the provisions of Article 136 very slowly and very carefully, because this is basically what is the bulk of the practice before the Supreme Court, civil and criminal SLPs, right? I'm reading 136(1) for everybody's benefit. It says, notwithstanding anything in this chapter, the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence, order, in any cause or matter passed or made by any court or any tribunal in the territory of India. Now look at it. Look at the fundamental elements. A, it's a special power. B, it does not say that it can only admit a petition by means of special leave from a high court or appellate tribunal. It says it can admit an SLP in any cause or matter passed or made by any court or tribunal in the territory of India. So it can be an SLP directly. Of course, the Supreme Court may refuse to exercise that discretion, but hypothetically speaking, that power the Supreme Court has to entertain a matter directly from any court or tribunal in the territory of India. So not just appeals from the High Court, but appeals from any court or tribunal should the Supreme Court feel that it should be admitted by a special leave directly. Second thing, the second element that you have to look at, it does not say that the special leave petition will only have to be filed after the matter has been decided finally by a high court or a tribunal or appellate tribunal. It says the appeal can be from any judgment, decree, determination, sentence, or order in any cause or matter. Therefore, in a fit case, even if there is an interlocutory order, an order granting interim injunction status quo, which is by no means a final order, a 136, hypothetically speaking, is maintainable. The Supreme Court may exercise its discretion and say that no, shouldn't come up directly in appeal, not a fit case for grant of special leave, but it is not like its jurisdiction is barred. And there are cases where the Supreme Court has entertained SLPs from interlocutory orders. There are cases where the Supreme Court has entertained SLPs directly from a court or tribunal, bypassing the High Court by means of an appeal. Right? About Article 136, there is one thing that you must remember, and that is the court's widest discretion to grant special leave as long as the appeal is from a judicial order. And therefore, in most cases, the Supreme Court may refuse to grant special leave. You will have seen in your internships for those who have interned in the Supreme Court that on miscellaneous days, when SLPs come up for the first time, most SLPs are dismissed. Very few are admitted. But the Supreme Court has the widest discretion to decide what matter to admit by means of a special leave. It has some rules that have evolved over a long period of time, certain limits to its discretionary power. For instance, the Supreme Court has held in various cases that a 136 special leave will be granted very sparingly, where there is a egregious violation, where grave injustice has been caused. And if you want to look at a seminal decision where the width of the Supreme Court's discretion in 136 has been considered, you could look at an old decision from 1955 in Dhakeshwari Cotton Mills. That will give you a flavor of the Supreme Court's discretion to either entertain or refuse to entertain an appeal by special leave. There is one limitation in terms of the Supreme Court admitting matters under 136, and that is you can only appeal a judicial order of a court or tribunal. You cannot, under 136, go up against an administrative action. It has to be a judicial action by any court, tribunal, high court, appellate tribunal that you assail before the Supreme Court. You cannot go up against a mere administrative action. And you could look at the 1963 decision of Jaswant Sugar Mills, which will give you an idea of that limitation that the Supreme Court has, in that it says Supreme Court in 136 will not entertain appeals where there is not an exercise of judicial power of a court or tribunal. Right? Having briefly spoken about the court's jurisdiction under 32 for writs as well as under 132 to 136 as an appellate court. We will very briefly look at the court's review jurisdiction. Now, review jurisdiction, in fact, is different from its appellate jurisdiction or writ jurisdiction, because like I said, for each of these is a separate criteria that you have to meet. What that means is you can't, as a matter of course, go ahead and file a review against a Supreme Court order. You have to satisfy some criteria before you are able to satisfy the Supreme Court that it is a fit case for review. You can see Article 137, it's a very generic provision that is there which grants the Supreme Court the power of review, but it is actually covered in Order 47 of the Supreme Court rules, which prescribes, and this is very important, a different threshold for review in civil matters versus review in criminal matters. In civil matters, you can satisfy that there has been a mistake, error apparent on the face of the record, or disclosure of facts which were not discovered at the time the main matter was being heard without any fault of your own and they were discovered later. If you satisfy that, you can maintain a review in a civil case. In a criminal case, a review is maintainable only if you can show that the Supreme Court committed an error apparent on the face of the record when the matter was decided by the Supreme Court in the first. And therefore, it is very difficult, actually, honestly speaking, to meet the review threshold. And in order to ensure that a lot of time is not wasted in hearing review petitions, the Supreme Court rules also say that a review could be decided by circulation. What does that mean? It means not all reviews will be heard in an open court. Because if that was the case, people would start having a second shot at every matter. They'll file an appeal first, appeal gets decided, they file a review, both times they heard in open court. To ensure that such a thing doesn't happen, reviews are generally decided in circulation. There are no oral arguments. If the court feels, of course, an oral argument can take place, but ordinarily that's rarely the case. If you want for your practical orientation, some examples where successfully people have been able to review decisions, you could look at, for instance, the case concerning the SC and ST Atrocities Act, which had actually dominated a lot of discussion in media and political circles, a question of tremendous importance. The Supreme Court had initially decided that the more stringent requirements of the SC-ST Atrocities Act would not apply, and that only after a preliminary inquiry one could file an FIR against a person accused under the SC-ST Atrocities Act. It also made the provision of anticipatory bail possible, so on and so forth. And then it was the litigants, the petitioners went up in review. And in review, the Supreme Court was convinced that it ought not to have diluted a law which has a special place of importance in order to do away with discrimination. And that's a good example of where the Supreme Court heard a review and it was entertained and not dismissed by means of circulation. But in most cases, it will be dismissed by circulation and one will not have a second bite. I move on to the next element of jurisdiction, which is the Supreme Court's advisory jurisdiction under Article 143. This is very, very, very important. And it's not something that happens on an everyday basis, but sometimes Article 143 petitions become extremely important because often there is a conflict, or at least a perceived conflict, in between the legislature and the executive on one side and the judiciary on the other, whenever a reference of this kind is sought. So it's politically very sensitive. Under 143, the fundamental elements are that if it appears to the president that a question of law has arisen or is likely to arise of such public importance that it is expedient to obtain the court's opinion, he may refer that question to the Supreme Court and the court may report to the president. This is a unique jurisdiction. If it appears to the president, doesn't mean the president wakes up one fine day and refers the matter to the Supreme Court. Appears to the president also has to be read with Article 74, which says that the president will be bound by the aid and advice of the Council of Ministers. So actually it is a reference to the Supreme Court by the Council of Ministers, and that too, only the Union can refer a matter to the Supreme Court for an opinion. It need not be in relation to a question of law that has already arisen, because it says has arisen or likely to arise. So technically speaking, they can also refer a question to the Supreme Court where the question is likely to arise but has not arisen already. Now, the reason why this jurisdiction is important and unique is because the Supreme Court here is actually rendering an advisory opinion upon a reference by the president. It is not deciding an appeal between parties. There is no lease which it is deciding. You don't have two opposite parties which are opposing each other, whose rights and liabilities are being agitated, and the court is deciding who is right and who is wrong. It is not rendering a judgment or a decision or an order. It is rendering an opinion in a presidential opinion, in a presidential reference. And that too, as the last few words of that Article 143(1) says, the court may, after such hearing as it thinks fit, report to the president its opinion thereon. Therefore, there is no strict provision as to how the matter should be heard. And when the article itself says that it may report the matter back to the president, it may give that opinion or it may not. Right? Some of the notable cases under Article 143, the most recent one that comes to mind is the case that's called in re Natural Resources Allocation. This was filed after the Supreme Court's decision in the 2G spectrum allocation case, where the Supreme Court had held that allocation of spectrum or distribution of a largesse has to involve price discovery, which best happens by means of an auction. So in this presidential opinion, the matter that was put, the reference that was placed before the Supreme Court for opinion was, does that mean that besides auction, there can be no other method by means of which Supreme Court allocates natural resources? In that case, the Supreme Court gives some guidelines about the kind of jurisdiction it enjoys under 143, and it held that 143 should not only have political or socio-economic questions. There must be some questions of constitutional significance, and the questions should not be hypothetical or matters which will not have any relevance. Earlier in 1978 and also in various other times, the Supreme Court has decided matters under 143 where it has given an advisory opinion. You should look up the case that's called In Re Special Courts Bill in 1978, where the Supreme Court held that it is not always bound to decide a reference that has been placed before it under 143. If it so finds fit, it can refuse to exercise jurisdiction and also cannot give an opinion, particularly when the opinion is purely speculative or hypothetical. And although it's not frequently used, like I said, because one has to be very familiar with the forum, one ought to know when is an Article 143 reference invoked and what's the court, what powers does the court have. Moving on very quickly and very briefly to the court's contempt jurisdiction. I hope at a practical level, none of you will be held in contempt and none of you will have clients who are held in contempt. But if that's ever the case, always bear in mind that the Supreme Court's power of contempt is actually constitutionally protected, and so is the High Court's power to punish for contempt. Therefore, it is not restricted by the Contempt of Courts Act alone. It's a constitutional provision that protects it. The Supreme Court also has rules, the Contempt of Supreme Court Rules, 1975. But the contempt power actually comes from Article 129, which says that the Supreme Court shall be a court of record and shall have all powers of such court, including the power to punish for contempt. If you're looking at some of the more important cases where the Supreme Court's power to contempt has been elaborately dealt with, there's a judgment that has come this week, Justice Deepak Gupta's judgment, in reference to contempt of Vijay Kurle, where the Supreme Court has held again, reiterating earlier law, that the power to punish for contempt the Supreme Court has also read with its power under Article 141(2) is a power that is not restricted merely by the Contempt of Court Act. It has far more powers than any other court. High Court's power to punish for contempt again also is constitutionally protected. This is a relevant article like Article 129. So always remember that you can't restrict these constitutional courts' power to punish for contempt merely to the Contempt of Courts Act. I move on to the next one, next element of jurisdiction, and this is something which has become the flavor of the season now, which is the Supreme Court's original jurisdiction. I want to stop here for a moment. You will all know that when we talk of original jurisdiction, we are talking of civil suits. We are talking of a suit where you move court in first instance by means of a cause of action. And generally speaking, it begins, a suit begins at the lowest court in terms of the CPC. And this is a unique provision which allows you to file a suit directly at the Supreme Court. Ordinarily speaking, we talk of the Supreme Court as a court of appeal. We talk of the Supreme Court as a court which renders advisory opinion, which entertains writs. We do not talk of the Supreme Court as a court which can entertain suits. But it has the unique power to entertain a suit. And that is under Article 131 of the Constitution of India. And the reason why I said that it is the flavor of the season is against the Citizenship Amendment Act, several states have filed suits against the Union of India. Earlier, when there were water disputes between states, several suits had been filed by one state against the other. And therefore, it may be worthwhile to have a look at Article 131. 131 actually reads, the head note says original jurisdiction of the Supreme Court, and it says, subject to provisions of the Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute. I stop here. The word used is shall, and to the exclusion of any other court. Therefore, if it's a suit that is covered under Article 131A, B, and C, then that suit is not maintainable anywhere. It is not maintainable before any of the chartered high courts exercising original jurisdiction. It is not maintainable in the district court. It is exclusively maintainable before the Supreme Court, and the Supreme Court, the word that is used to describe that exclusive jurisdiction is shall, to the exclusion, have original jurisdiction. Now look at the kinds of matters in which the Supreme Court exclusively has jurisdiction to decide suits. That is, suits between the Government of India and one or more states, Government of India and any state or any states on one side and one or more states on the other, and between two or more states. I will be very brief here. Therefore, it is, as you can see, it has to be a dispute involving two or more states, or government on one hand and state or states on the other hand. The notable cases are the State of Bihar versus Union of India, decided in 1970, where the Supreme Court said that when you say government and state, it doesn't mean state versus a government instrumentality or authority. So a state like a State of Bihar can't go ahead and file a suit against say a PSU, saying that it is actually controlled by the government of India. It has to be a suit between government of India, one or more states in federal capacity. You're looking at an exercise of executive power or legislative power by the government of India, an exercise of executive power and legislative power by a state. And in exercise of these powers, if one is aggrieved, then one can file a suit. The other important aspect is the last bit of Article 131 before the proviso begins. It says the dispute must involve any question, whether of law or fact, on which the existence or extent of a legal right depends. Now, therefore, this clause in an interpretation was sought to be given to this clause, saying that 131 Supreme Court's jurisdiction is very limited. It can only declare a right or extent of a right, but the Supreme Court has held in many cases, including in the state of Karnataka versus Andhra Pradesh in 2000, and in the state of Rajasthan's case versus Union of India in 1977, that it does not just extend to Supreme Court deciding a question of extent or existence of a right and declaring that, but it is more expansive. The Supreme Court can go ahead and pass an effective order in matters under 131. There is one more practical aspect that I want you to keep in mind in 131. The provision begins with saying, subject to the provisions of Constitution, the Supreme Court has jurisdiction. What that means is, if the Constitution somewhere else says that for certain kinds of matters jurisdiction will lie elsewhere, then this article is subservient to it. So, for instance, for water disputes, there's a specific provision where it can only go under the Water Disputes Act of 1956. Therefore, those matters are now barred. So if there is a state versus another state where a dispute is solely to be decided under the Water Disputes Act of 1956, then that matter between two states can't be decided under 131. The Supreme Court has now, however, held that if there is a decision of a water tribunal which you are seeking an implementation of before the Supreme Court, then that you can do by means of a 131. And therefore, the power is not just restricted to the declaration of rights. The power is not just restricted to declaring the extent of rights. The power is limited in case of water disputes, but provided there is already a decision by a tribunal, the power to implement it is not restricted. I move on very quickly to the Supreme Court's jurisdiction under Article 71. I will not labor too much. These matters don't really come up. You can have a look at it in relation to election of president and vice president. Again, it's a jurisdiction that is unique to the Supreme Court, where the decision in relation to such matters are final as long as decided by the Supreme Court. Very briefly, moving on to the Supreme Court's jurisdiction to decide curative matters. We've spoken about review matters. A curative comes after review, provided you are able to show that there is something which requires the court to have a look, even though the review was decided. It's very difficult to meet the curative threshold, but there are specific provisions in the Supreme Court rules that deals with curatives, and you have to get a certificate of a senior advocate, a certificate of an AOR, but then again a curative can again be disposed of by circulation. Again, it can't be a matter of ordinary course that you file an appeal, a review, and then curative. Appeal itself very hard to meet the threshold, review even harder, curative almost next to impossible unless you're able to show something which is absolutely grotesque that has happened. Unlikely the Supreme Court will entertain a review or curative. Very unlikely that the matter will actually be heard in open court, and it might be disposed of or dismissed by circulation. The Supreme Court also has jurisdiction to entertain transfer petitions. I will not go into the details of the provisions, but you can have a look at Section 406 of the CRPC, Section 25 of the CPC, and Article 139(1)(a). As long as you are able to satisfy the jurisdictional threshold, the Supreme Court will entertain a petition and transfer a matter from one court to another. Under 131(a), it transfers matters on questions of general importance to itself. Under 131A subsection 2, it can transfer any case, appeal or procedure from one high court to another, and it's not just restricted to criminal cases. So if you want to look at its transfer powers in criminal matters, look at 406, look at section 25 of the CPC for civil matters. 139A is the constitutional provision which grants it exclusive powers to transfer matters. With that, we've broadly covered the issue of jurisdiction of the Supreme Court. I'll just take 10 more minutes to briefly take you through pleadings. Now, like I said before, it is one thing to know which court can hear a matter, which you consider when you're looking at jurisdiction. It is quite another to be comfortable and confident with what to plead before that court, right? And the Supreme Court hears different kinds of matters. Look at SLPs. We've not covered statutory appeals, but there are statutory appeals the Supreme Court hears, say from an NCLAT or an NCDRC. You look at writ petitions under 32, PILs, original suit. Each of this will have a different nature as far as the pleadings are concerned. But broadly speaking, there are 5-6 things that you should remember when you make a pleading before the Supreme Court. First thing is, of course, delay or limitation. If you're moving a writ petition after several years, unlikely the Supreme Court will entertain unless you're able to make out a sufficient case for delay. Same, if you're moving an appeal that is barred by limitation, you have to be very careful what line you tread. Either you have to be able to show that there are grounds under which limitations stood extended. For that, you need to look at the Limitation Act, or you must appropriately file an application for condonation. So the timing is important. When do you approach and how do you plead a case for condonation where you are in delay, right? Second thing is, there has to be in Supreme Court pleadings a full disclosure of facts. You have an LOD, list of dates, synopsis, make that crisp. But the first duty, of course, is duty not to mislead the court. So you cannot selectively choose facts and state something and leave the rest. The second thing. First thing is, how do you deal with delay? Second is a full disclosure of facts. You may explain your facts, but never suppress anything, must disclose everything. Third is grounds. You must ensure that the grounds are not completely disconnected to your pleadings. They have to flow from your pleadings. They have to flow from the case that you have at hand, the application of facts and law. And more importantly, there are no surprises. Make sure you take your grounds in a manner so that at the stage of arguments, when it comes up, you don't feel that you're left high and dry, because certain grounds you ought to have taken in the petition, but you didn't. So as far as grounds are concerned, make sure that there's a connect between your pleadings and the grounds you take. Those are the grounds that you will thereafter take when you make arguments. And all of this has to be based on what was there before the High Court. You can't really come and surprise the Supreme Court by saying that, look, there's something else that I pleaded before the High Court or an appellate court, but here I am, I want to plead a new case, right? So that's as far as your delay, limitation, disclosure of facts, grounds is concerned. Fourth thing, Supreme Court generally, you will be confronted with questions of law. And unless you're able to show that there's a tremendous question of law or a question of enormous significance or constitutional significance, unlikely that an appeal or a writ or a statutory appeal will be admitted. There are some easy gateways of satisfying the threshold. For instance, if you're able to show that there are conflicting decisions of the High Court which requires clarity upon, or conflicting decisions of benches of co-equal strength, then of course the chances of admission are higher. Otherwise, on a question of law, you must ensure that the question is framed in such a manner so that you are able to convince the Supreme Court that there's something very serious involved, or there's something which requires the court to have a relook, or there has been some manifest injustice in terms of how the question of law or fact has been addressed. And therefore, it can't just be run-of-the-mill application of a statutory provision and you say that it's being wrongly applied, right? You have to be able to evoke in a judge that sentiment that this is a matter that's fit for the apex court to hear, because of the way the questions have been wrongly decided by the court below. Right. The last thing is, of course, cause of action. Differs in an appeal. You draw that from what has happened in the lower court. In a writ, your cause will basically be the infraction of fundamental rights. In a PIL, similarly, again, you'll have to show infraction of fundamental rights, but the locus is relaxed. In any other matter, depending on the kind of matter, you have to look at the facts and the law, and taken together, you'll have to plead the grounds which therefore will entitle you to relief before the Supreme Court. But these are the 5 things that you have to consider in all pleadings before the Supreme Court. Delay/limitation first, disclosure of facts, full and frank disclosure along with appropriate explanation. Third, appropriate grounds to be taken. Do not miss out grounds. Do not take new grounds. Make sure that you don't take grounds which don't apply. Fourth, draft the question of law appropriately. And fifth, make sure that you make out the cause of action that is required depending on the case that you have at hand. If you want to look at one of the formats, the SLP format is annexed to the Supreme Court rules itself, so you can have a look at that. It's fairly straightforward, but of course, ultimately it's the lawyer who has to draft the case and make sure that it is fit enough for the Supreme Court to entertain the special leave. Now, moving on very quickly to how courts are constituted, and we're running out of time. I have to wrap up by 6:30. I'll just very briefly speak to you about the provisions. And this is the second last topic that we will cover, which is how the court functions. Ordinarily speaking, every appeal is heard by no less than 2 judges, right? And this is important because often you hear wild allegations about bench hunting. There's lack of clarity about how matters are placed before benches. You are confused as to why a matter goes before a 3-judge bench and not a 2-judge bench. You don't know when a matter will be heard by a 5-judge bench. There is some clarity in the rules and decisions that have been rendered by the Supreme Court from time to time. I'll just very briefly go over them. Ordinarily, the rules prescribe that every appeal will be heard by no less than 2 judges. This is Order 6, Rule 1 of the Supreme Court rules. There are some matters that can be heard by a registrar, and there are some matters that can be heard by a judge in chamber. And those are dealt with under Order 5, Rule 1 and Order 5, Rule 2 of the Supreme Court rules. You need not memorize them, but if your matter is ever placed before the judge in chambers or the registrar, you ought to know whether that is a matter that can be placed before them or should it go before a DB, right? Registrar, for instance, as you will have seen in your internships, deals with matters about surveys or delay in refiling. Eventually, the powers of a registrar to condone are limited. So if, for instance, the matter is repeatedly coming up before the registrar, then a party is not filing its reply despite a notice, then it will go up before a bench eventually. Similarly, you have a vacation bench, which hears urgent matters. That is dealt with under Order 6, Rule 3 of the Supreme Court rules. You can familiarize yourself. It decides urgent matters in vacation, but generally not involving matters which require interpretation of the Constitution. But it can grant interim relief and transfer cases. You can look at the powers of a vacation bench. Besides, you have 3-judge benches. A particular kind of matter which has to be heard by a 3-judge bench is a matter that involves a death sentence. That's dealt with under Order 6, Rule 3. And then you have what we call a constitution bench. You can look at Article 143, which says that wherever there is a substantial question of law as to the interpretation of the Constitution, or wherever there is a presidential reference, there has to be minimum 5 judges. And you've looked at constitution bench decisions that have had more than 5 judges. You've looked at Keshavan Bharti, you've looked at Gopalan, you've looked at the entry tax matter, you looked at Ayodhya. Depending on the kind of matter, if it's important enough, it can be 5, 7, 9, 13 judges. The right to privacy judgment, of course, was also a judgment that was by more than 5 judges. If you want to understand how the hierarchy goes about. When is it that a matter will be placed directly before a 5-judge bench? When is it that a matter will be placed before a 3-judge bench first? You could look at this decision in Central Board of Daudi Bora Community, which is a decision in 2004, which says that ultimately it's the Chief Justice who can place any matter before any bench, which basically, of course, is also the concept of the chief being the master of the roster, as decided in Ashok Pandey and Shanti Bhushan's case, Justice Chandrachud and Justice Sikri's opinion. So if a Chief Justice feels that a matter is of tremendous importance, that matter can be placed before a constitutional bench. Otherwise, if that's not the case, then the law of precedent applies. A bench of larger strength will always bind a bench of co-equal strength or lesser strength. A bench of lesser strength cannot question a decision of a bench of larger strength, but in case of doubt, it can request that the matter be placed before the chief, and the chief can then constitute a larger bench. A bench of co-equal strength can question the correctness of a decision of an earlier bench of co-equal strength. And in that case, again, the matter will have to be heard by a larger bench if there is a conflict. But as I said, none of these general rules apply when the chief, in his discretion, places a matter to be placed before any bench. Now, very quickly moving on to the system of AORs. Briefly speaking, this is again, AORs are unique creatures that you see in the Supreme Court, yours truly being one of them. Order 4 emphasizes on the need and importance of AORs. Briefly speaking, the Supreme Court rules state that only an AOR can act primarily for a party and can act or plead or file a wakalat, enter an appearance. Upon instructions of an AOR alone, can a Supreme Court, can a senior advocate or an advocate appear? And therefore, basically, without an AOR in every matter or in any matter, a party cannot engage either an advocate or a senior advocate to act, appear, plead, file wakalat, enter an appearance, so on and so forth. And therefore, the court regulates through this process of AORs the advocates who are the primary interface or connect between the bench and the litigants. And because the Supreme Court strives to maintain some standards, it expects a certain standard of advocates alone to act, appear, plead, or even instruct and brief seniors. Therefore, there is a system of examination by way of which AORs are chosen. Syllabus, of course, as you know, involves practice and procedure, jurisdiction of the court that we've broadly covered. Then you have a paper on ethics. You have a paper on leading cases. And it is an examination that you can't take immediately upon becoming an advocate. And separately, there's a fourth paper as well to the examination, which is basically drafting, the part about pleadings that we went through. The examination is held every year. And once you qualify as an AOR, which can only be after 6 years in the profession when you're eligible to sit, you can then start acting, appearing, filing wakalats, instructing seniors on behalf of clients who have matters in the Supreme Court. To conclude, always remember these unique constitutional provisions that we went through: 32, 129, 143, the provisions of appeals under certificate from the High Court, appeal by means of special leave. And always keep in mind that the Supreme Court has the unique power, which other courts don't enjoy, to pass any order which, in its opinion, will do complete justice. And it has full powers to enforce orders, including by sending people to jail. These are some unique powers that the Supreme Court enjoys. And with that, I think we've covered most of what practice and procedure entails. This was just to familiarize you with how the court functions and what broadly the court looks at. Of course, as I said, you could never really know where is the end of this quest to fully understanding practice and procedure. This is something you learn as you practice, but it is important to familiarize with what are at least the essential features of a practice before any court. And today's today's talk rather, was just an attempt to help you familiarize with the different elements of practice and procedure before the Supreme Court. If you have any queries, you can email them to me, and Ankush can provide my email ID. I don't know if I should answer them now or
if you have the time, you can answer it right now. If you're okay with it. We have a few questions.
I have a question from Tanmay, which says, when High Court has power to decree against a person, do we interpret it as an individual or a legal person? Yeah. So basically, when you mean power to decree against a person, I'm guessing you mean the power to pass a decree against any person. I don't know if you're talking of civil suits or writs. High Court's power to issue writs is against any persons, as long as the person is discharging a legal duty. Any High Court has the power. If you're talking of the High Court's power to decide an original suit and pass a decree, then that power only those High Courts have which have an original side. So ordinarily a decree is passed by a lower court in a civil suit, like a district court. They pass a decree after they determine issues, and there is a trial and a civil suit is heard. After that, they pass a decree. So if you're talking of that kind of a decree, like a decree in a civil procedure code context, there can either be a court which is High Court, which is original jurisdiction, or a civil court which is lower than the High Court, or the Supreme Court under 131. If you're talking of the High Court's power to issue a writ, using the word decree loosely, that is, then it can issue it against any person, any legal person, any individual, as long as they are discharging a public duty. The second question is by Abhinand, who says, regarding the recent suits filed under 131 with respect to the CA by various governments, isn't the extent of 131 restricted to questions of legislative competence and not questions of fundamental rights, considering that citizenship is a union list entry and there will not be a question of legislative competence? Well, I'll give you an example of a 131 case where you're not strictly looking at competence. You can look at the decision in the case of State of Haryana versus State of Punjab, which was about the Satluj and Yamuna link canal, where one of the states had performed their duty to dig a part of the canal and the other didn't. And then they went up to the Supreme Court. And the Supreme Court held that it was a suit that was maintainable, in fact, under 131. Therefore, it need not just be restricted to questions of legislative competence. In the past, where a particular question of dismissing or particular kind of advice purported to be given to the governor by the Council of Ministers at the level of the state is concerned, where such questions have come up, original suits have been filed in the Supreme Court. You can also look at State of Karnataka versus Andhra, which is not strictly speaking a case of legislative competence. And while therefore competence may be an issue, but like I said, 131 says to any question of law or fact, not just a question of law, on which the extent or existence of a legal right depends. So that itself will make it clear that you are not just strictly looking at the question of legislative competence alone, right? It can be on any legal rights and not just the right to enact laws where you are competent. There's a question by an anonymous attendee. If online proceedings become a regular affair, will become more accessible to litigants, do you think it means the role of an AOR? There are three questions. Would making a failed attempt to obtain a certificate of fitness preclude you from filing an SLP if the certificate was rejected? Would it not prejudice? Since the pleadings have to be linked to ground, do AORs out of abundant caution invoke every possible ground? Well, I'll just try to answer that in brief. Well, I mean, even if online proceedings become a regular affair, since you can't act, appear, plead, file or wakalatnama without an AOR, I mean, still matters will have to be done through an AOR. And even if an advocate wants to appear in online proceedings, he or she will have to be instructed by an advocate on record. That's as far as the rules stand as of today. If that changes, that changes. But even in the online system, it's unlikely that the concept of AORs and the rights that they have and the position that they have under the rules will be completely done away with. Of course, because you are dealing with an extraordinary situation, there is some relaxation in every norm. You are, for instance, not required to file an affidavit. You file an application saying that everything stated in the petition is true, but I'm not swearing. The petitioner is not having to swear as to the correctness of facts that are pleaded. So there are some relaxations, of course, because you have a public health emergency. But if there is no health emergency, but matters are being heard by online means, it is unlikely that the system of AORs and these relaxations will be done away with. If you have an online system, you will still have to have your affidavit sworn, or you will have to have some testimony or notarization. You will have to have an AOR. Only the mode in which you are heard will be online. Rest of the things will remain. And regarding your question about certificate of fitness, well, I mean, of course, 136 does not bar you from moving the Supreme Court for special leave. So that's something that's always available. In fact, there is law to indicate that a High Court certificate under 132 may not always be binding upon the Supreme Court. So frankly speaking, therefore, 136 has become the mainstay of practice. Nobody takes the extra effort of going to the High Court and obtaining a certificate of fitness, when anyway the Supreme Court will exercise its discretion and not entertain a matter. And rather, petitions are filed directly under 136. Supreme Court can, in an appropriate case, grant leave or dismiss it, as the case may be. Your third question is whether advocates take every possible grounds. Well, I mean, I won't deny that this is unfortunately something that's quite common. They generally take every ground because there is the insecurity that if they don't take a particular ground, they may miss out because it may come up in the course of hearings. I think it has to do more with advocates being slightly insecure about what is going to happen in an eventual hearing. They don't want the blame to come on them. Therefore, they just make sure that everything is there. But I think as a good practice, one should avoid taking grounds that are frivolous or nonsensical, really.
Yes, I think that's all the questions. Thank you, sir, for this extremely comprehensive and informative session that we have had. Thank you, everyone, for attending. I hope, sir, we can have you soon on campus when things are normal. Thank you for
absolutely. It was a pleasure. Thank you so much. I hope it was worth your time, and look forward to interacting with you people again. Thank you.